Well, I know the panelists are anxious to take your questions and also round out their comment.
I have a question for Professor Geisfeld. We chatted a little bit about this last night, but I think your theory of punitive damages as making up for inadequacies in tort damages is very intriguing. I guess my first reaction to it is to agree a little more with Kathy Sharkey that there does seem to be another solution one could take to that, which is hedonic damages or some other kind of approach. Because it seems to me that the problem of inadequacy of wrongful death damages is pervasive. It's not just a problem with extremely wrongful or culpable behavior. It's a problem even with slight negligence that ends up resulting in serious harm to others. And one actually, I mean, when I think about hedonic damages here, I also see there's a parallel potentially to what we do with punitive damages in some jurisdictions, as Kathy was talking about. Split recovery makes a certain amount of sense for punitive damages and maybe for hedonic damages too. When the victim is dead and can't benefit from the receipt of compensation, it does seem like a bit of a windfall to the family to get all those hedonic damages. So maybe we should use that punitive damages scheme of split recovery. But in terms of actually awarding punitive damages whenever we've got wrongful death. And I'm sure I'm oversimplifying your argument, but it looks like that's what you're at least initially arguing for. That seems to be too strong for the reason I just said. In ordinary negligence cases, would you really want to do that? And maybe also too weak. In Keith Hylton's example of property damage that's brought about by extremely egregious behavior, presumably we might want punitive damages there too. So I'd just be interested to know why you fit it together into your argument the way you do.
In the interest of seeing more elbows fly among the panel members, I tend to share Ken's intuition that I was asking the same question. Would you really like to do that? You know, you're saying that general damages are undercompensate. Would you really want to have punitive damages as a general remedy for that problem? And I guess I would start asking, well, what are the areas in which I think under-deterrence is going to be a big problem, and where would I think over-deterrence is going to be a big problem? And I would take your approach where I think under-deterrence is going to be a big problem. I'd be more sensitive to that question in trying to design the solution.
I don't hear any mention of the states that don't allow punitive damages. Massachusetts, as I understand, doesn't allow them. Washington State doesn't allow them. If there are states that don't allow punitive damages and we don't see any marked evidence of different calculus in the whole function of the tort system, what does that tell us about this whole discussion?
I guess I'll take a stab at it. So Michigan, I think, abolished punitive damages, and Massachusetts, I guess, doesn't have punitive damages. And the fact that the sky hasn't fallen in either of those states does mean you could live without punitive damages. On the other hand, it would take an empirical test to determine whether there's some difference in the way life works out in these two states. And for example, is there more corporate fraud, small-time or big-time corporate fraud in Massachusetts than other states if you were to control for all of the other factors? I don't know. You know, I can tell you from experience there are a lot of small-time, fly-by-night operations in Massachusetts, and I was kind of surprised when I moved there of how many there are. But I don't know if I can't say myself whether that's more than in other states, and someone would have to do an empirical test and control for a lot of other factors and see whether the absence of punitive verdicts or the threat of a punitive verdict leads to different behavior in corporations, local corporations.
I have a couple questions for the whole panel. First of all, I'm referring to Tony's reference to England. They have uniform health care and wage replacement programs so that a large number of suits are not brought. So I don't think it's a appropriate reference for our situation. And also that suggests that maybe if one of our candidates
does bring forward uniform health care, that it will change the number of the kinds of suits we get in torts. When I looked at it in England, what I found was there was little reason to sue. I mean, if you had your 3/4 of your wages taken care of and all of your medicals taken care of, why do you want to get in the courtroom? So we may end up having a lot less torts than we do. The other question I have is a more general one. Is the Supreme Court not meaning what they say? In other words, are they really trying to speak to plaintiffs' attorneys and say, you're going to have to come visit us, we're going to talk to you, add another $250,000, $500,000 to your case? Is it really worthwhile to play around with punitive damages? Shouldn't you forget them? In other words, instead of all the sophistication that all of you have been looking at, is it really a more blunt instrument that the court is using to try and reduce punitive damages?
You know, I guess there are a lot of reasons people don't litigate as much over there. You have the English rule, so that if you bring a lawsuit, then you're afraid that if you lose, you end up paying the other side's legal fees. And if it's a big corporation and they've got expensive lawyers on their side, I think that would be, you know, a strong disincentive to bring lawsuits. And so there are all sorts of, you've mentioned the social welfare system as another reason why people, why there are lower rates of litigation over there and why we'd see more litigation here. And I guess I'm inclined to view that as somewhat independent of the question about punitive damages, whether punitive damages make sense or not, because we can change around the procedural rules here to make people less likely to sue or more likely to sue. The bottom line is whether we want to have some consistent doctrine on punitive damages, something that makes sense. That, I think, is a question that we can address independently of the procedural devices that let people, you know, come to court easier or less easier. The other comment you had about the court having a blunt, I didn't quite follow what blunt instrument you had in mind when you said the court is applying a blunt instrument to punitive damages.
When you're going to have to appeal your punitive damage award, therefore you may not seek it, you may not take cases.
Well, they're just trying to make you run the block 5 times
Yes.
for a punitive damages verdict, which looks like what some justices want to make people do. That's all I have to say.